Good evening, everyone. Thank you for coming. I know the view's entirely distracting, so I will forgive you if you're looking out the window rather than listening to me at the moment. Thank you very much for coming. I'm delighted to welcome all of you here. And my real thanks goes to our EBC Vice Chair, Sarah George, who is here at Sidley, and for Sidley for hosting this very important event. And also to the KCA, to Hannah and to Jackie, and to Monisha Shah and to Dame Anne for giving up their time and for supporting us to come here and speak to everyone here and online. To have both Monisha and Dame Anne speak to us about the application process, I think is significant in a number of ways. First, their collective wisdom and their insight and their involvement in the process is invaluable. And I hope all of you are going to take a great deal away from this evening. But second, the fact that we're holding this event for the Employed Bar is an important milestone in the Employed Bar's history. The EBC celebrates its 25th anniversary this year, and when I was called around the same length of time ago, the EBC didn't exist. Employed barristers were a relatively unseen and uncelebrated minority, and the idea of taking silk as a member of the profession in employed practice seemed rather remote. But when we fast forward a quarter of a century, I am really proud to chair the committee this year that represents some of the most diverse quarters of the profession, members of the bar working in senior positions across government, commerce, finance, industry, the public sector, and the armed forces. And that wealth of experience, that expertise and talent is something to celebrate, as is the progression and the visibility that the Employed Bar has achieved in the last 2 decades or so. More employed barristers are thinking about and taking silk. Now, my own experience in doing so was no less testing. I did actually write arduous then, but I thought that would be unfair to say that, especially as Monisha was one of the people who interviewed me. But it was no less testing than any other applicant. But I say this genuinely, I was really struck when I took that decision by how helpful and encouraging and open the then, as it was known, QCA was. At no stage of the application process did I think it wasn't for me because I was employed. Far from it. In some respects, my role within the civil service department meant that I had several examples of equality and diversity, and also working with others, 2 of those important competencies to draw on that practitioners at the self-employed bar might not have been exposed to. And then on appointment, I was asked if I'd be happy to be featured as a successful applicant on the website to encourage other people from different parts of the profession to apply. And I'm delighted to say that there continues to be real positive, open and productive dialogue between the EBC and the KCA, which can only assist in our aims to encourage more people at the Employed Bar to consider and apply for silk and to further that diversity within the profession. Because the Employed Bar is incredibly diverse statistically, and it must follow that if more of our members of the Employed Bar take silk, thus the diversity of the profession as a whole is improved. So I really do hope this evening's seminar demonstrates that real commitment to progression, and from a practical point of view, encourages more employed advocates and practitioners to apply. Put simply, if you can demonstrate excellence across those competencies, it matters not whether you are employed or self-employed. So I'm going to hand over to our 2 speakers, both of whom are inspirations and role models in their own right. Monisha is chair of Wikimedia UK. She is also the senior independent member of the Arts and Humanities Research Council and a member of Ofcom's Content Board. In a voluntary capacity, she serves as a trustee of the Art Fund and of Caterham School. In previous roles, she was a board member of the Office for Students, chair of the Rose Bruford College of Theatre and Performance, and served as a trustee of the Tate, the Donmar Warehouse, the National Gallery, and the Foundling Museum. And in 2007, she was appointed trustee of Tate, prime ministerial appointment. And in 2022, she was invited to join the Royal Collection Trust as trustee by Her Majesty the late Queen, but it doesn't stop there.
You can stop there.
No, well, no, Monisha, as I say, I have my own experience of being interviewed by Monisha, and I can genuinely say that when I came out of that interview, as terrifying as it has to be and was, I genuinely felt that you and the other interviewer had given me the opportunity to deliver my very best. So please listen to everything that Monisha has to say, because she is excellent at what she does. And of course, Dame Anne Rafferty retired from the Court of Appeal in July 2020 as a silk at Criminal Bar, 1989 to 1997, Secretary, Vice Chairman, and then, of course, the first woman chairman of the Criminal Bar Association. Also the only barrister member of the Runciman Commission on Criminal Justice, de facto chairman of the Criminal Procedural Committee, vice chair of the Judicial Appointments Commission, and chairman of the Judicial College, and also the Chancellor of the University of Sheffield. With all of that experience, how can we not gain something from this evening? So thank you very much, both of you, and I will hand over to your extensive and collective experience.
Heidi, thank you so much. And thank you to Sarah for organizing this for us. It's a real pleasure to be here. And in spite of all of the long CV that Heidi kindly read out, I can tell you that this is one of those roles that I truly enjoy. I find very intellectually stimulating, and I'm very proud to do. So, thank you very much for the opportunity to the legal sector. I've been a lay member of the panel for about 4 years. I've been chair for 2, so that's 6 years. We're about to enter my 7th year of this competition. The employed bar is very interesting. I find it very interesting because, exactly as Heidi has just pointed out, 20% of all barristers, I understand, are employed barristers. And we know that more than half of this group work in the public sector, and a further quarter work in solicitors' firms. It's also incredibly diverse. I mean, I was really interested to read that women make up 49% of the employed bar, as opposed to 37% of the self-employed bar. 19% of employed barristers are from an ethnic minority, and 9.3% declare a disability, as compared to 6.6% in the self-employed bar. And it is possibly more common for employed barristers to be primary carers in comparison to the self-employed bar. The interesting statistic for me, however, is that employed barristers are incredibly underrepresented at KC level, only 2.6% compared to 14% of self-employed barristers. So that is interesting. And one of the reasons that we wanted to do this is to ensure that we as KCA are doing whatever we can to make it easier and more clearer for the employed bar to feel that they can apply to the process. So our job here is to explain the process as best as we can, answer any questions you have. And if there is guidance that we can improve on in terms of our own guidance to assessors and applicants based on your experience, then we'd be very happy to hear it. So that's why we are here. And above all, as Heidi said, the main message to take away, if you take away anything, is this idea that no employed barrister should think that silk is not for them. That is the primary message we are here to give you today. Provided that you can fulfill the competencies, there is no reason why you shouldn't apply. We're going to, thank you very much. Overview of the appointments process. So what we're going to do, Anne and I, today is just take you through the appointments process. It's carried out, as you know, by a selection panel. It's supported by a wonderful secretariat. Hannah is chief exec, she's sitting in the green dress. And Jackie Fraser is another wonderful member of our team who is responsible for this evening. The process is renewed for each competition. It relies on fresh assessments every year. So the framework you may not know, but it's a framework that's set up by the Law Society and the Bar Council. It's not set up by the KCA. The KCA simply apply it. So the idea, the competencies, the way it's set up is by your sector. The panel currently comprises, it says currently, because in the past it used to have 1 judicial member, we now have 2 judicial members, 2 barristers, 2 solicitors, 5 lay members, and the chair is always a lay member. We have a lot of information about the panel and our work on our website if you're interested. I think the key point I would like to make here for this slide is that the panel and as the process, we don't carry over any information. So if, for example, you have applied before, we don't use the information forward. It's fresh every year. We ask assessors for assessments every year because we acknowledge that people's careers progress and they get more experienced, or indeed the assessors know them more, sometimes to their detriment. So it can go either way, and we make no judgment. We will look at every application in the round as a fresh application in that year. The next slide talks about excellence. The key thing about the process is we want applicants to demonstrate consistent excellence in advocacy in England, in the law of England and Wales. That is fundamentally what the process is about. Applicants must demonstrate excellence across 4 competencies, you know this, and we want the examples to be from cases of substance. And substance is defined as it could be substance, complex, could be particular difficulty or sensitivity. And it's quite important that that is drawn out. And we'll talk more about some of the competencies individually. There are no quotas. I think it's very important that we say this again and again. We don't have any quotas. So any applicant who reaches the required standard will be interviewed. And the standard is determined by the assessments. So there is judgment. The panel does judge, the assessments, but we rely overwhelmingly on the evidence given by your assessors, people who know your work and who have taken the time to write up your evidence for us. So that's what it's based on. And provided that that meets the criteria and reaches a benchmark that the panel judges suitable, we will call to interview. So there are no quotas. Successful applicants, it's worth laboring the point for a moment, need to be able to demonstrate consistent excellence. So it's not just a flash of brilliance, which most people who apply have. And that's very, very interesting and very important to me, because we see that, especially as a lay member, I'm always super impressed. But what we want is consistent excellence. So your assessors should be able to tell us, across all of the cases that you put forward, that there was a consistency of excellence in advocacy and in understanding the law, in working with others in diversity. So that's quite important to keep in mind. I will now hand over to Anne.
I'm going to stay sitting down here, assuming that I'm seeing like Bella and everybody can hear, just so we can look together at the slides. So what we equip ourselves with is provided by the applicant. 12 cases. Do you need me to be over there?
No, I think everyone can see it. Those are online here.
Yeah.
You might need to wear them.
It'd be quicker if I go over there. It might be infinitely adaptable.
I think it does need to be microphone. So
Yes, because otherwise those.
All right, well spotted, Monisha. Right, so what we're interested in is securing from the applicant 12 cases from kind of the last 3 years. That's the ideal. But if it's not possible to provide 12, and if you think about it, it sometimes isn't, because one has gone on a particularly long time. It's the case of the career, so it tends to rule out others, or for some other compelling reason. You just need to say so on the application form. We're used to life as she has lived, but tell us, don't just leave it, spell it out. And as Monisha's already trailed, we want cases that are of substance. A list of cases which are pretty well the day job will be a long list, and there'll be cases which are the day job. So we want something that bites, and the more cases that bite and give you heft to your application, the better. And they need to stand out in some way. So they could be new law. They could just be unusual on their facts or aspects of the law. Or you could suddenly trip over complexities that hadn't been seen by you or anybody else. Or suddenly, or not suddenly, there are consequences that will run beyond the end of the case. That's not exhaustive, but I hope that that will give you a reasonable feel for the quality of what we're looking for. Then we get, from the 12, we start working out the assessors, or rather the excellent secretariat starts working out the assessors. So there are 12 judicials, and from those 12, the panel will take 4, so judges or judge type people, or former judge type people. And one of them, the applicant will have been able to name. The 12 practitioners, 3 assessments, same thing, 1 the applicant will be able to name, and that's quite often an opponent or someone co-defending. And the professional client, 6 of them, we'll take 2, 1 nominated by the applicant. And that, as you can see, we realise could be a bit more of a challenge for employed barristers than self-employed, because listing 6 could be more difficult than might at first appear. So for a start, given that, take it that we will be understanding about that. Don't suffer in silence, tell us, because your client is often your boss. You need to think about it. So then what do you do about the potential assessors? Well, hang on a second, I haven't finished yet. Thank you, really. So do tell them that you are planning to list them, and because it's non-controversial, just telling them, and it gives them an opportunity to raise anything with you, but don't go too far. Don't draft something for them unwise, awkward, and don't check up with them whether they've been approached. Also awkward. Right, I'm ready now. You can go to, right, jolly good. Right, now the self-assessment. Now this is you telling me about you, and that's really what I want. Most of all, I want to understand you. So show me, bring yourself off the page. I want to see the detail of what you do. I want the highlights of your career. I want to hear about your cases. And I want some background too, and that's the context. That's the let me understand the sort of work you do and what has set the scene for your application. And you might find me saying more than once. I'm going to say it for the first time now. I am not interested in or looking for perfection, and therefore I'm not looking for you to slot yourself in to what you think is the shape of the perfect applicant. Not at all. I just want to understand you. And when I do, I'll get on with it with the rest of the panel. I really will. So show me who you are. Warts and all, I like warts. Right. Now, the panel looks, as you know, Monisha's told you, against competencies, and there are 4 of them. Competency A is, can you master the law and then apply it correctly? So you've got to be up to date. You've got to master new areas quickly. The panel will often ask you about that. And you've got to be able to pull it off when you do. B is split. It's advocacy, but it's written and it's oral. And that might mean quite a lot to some of you, where your advocacy is more written than oral. We understand that. That's why it's done. But the thing that runs through everything is the advocacy must advance the case for which you are arguing. That's the thing to hold on to. Write it or say it, or write it and say it, but that's what it is there for. And you're after the best outcome in the dispute. C, working with others. The award of silk marks out a leader. It marks out an example to the profession. It marks out a beacon of shining excellence. And that's what you're looking for. So you want evidence now of leadership. And that comes in part from productive relationships. It won't go well if you can't work with other people, and particularly if they can't work with you. So show us that you can and they can. And a really high standard of getting on with it with them, collaborating. That's not making you a pushover. It's just sensible collaboration, because that's progress. That's the way you progress to a best outcome. And D, diversity, action and understanding. Got to understand diversity. Just a top tip, don't turn up with a whole load of statistics and nothing more, because we all know them. If you're going to use statistics, please feel free, but use them as a platform to make your point. And your point needs some more warmth to it. And that's, for example, what does inclusion mean? It's not just a noun. Translate it for me. So again, I'm beginning to understand you. And I want to see what's proactive about you. So if you spotted a gap and filled it because you know you can make a contribution, or have you joined in with something that is pre-existing? I'll take either. I just want to know that you've got it. Right, next slide, please, Chris Whitty. Thank you. So a lot of people do pro bono work through Advocate or any other pro bono charity. And that's quite a natty way of pulling in evidence for an application. And forgive me if it sounds patronizing, I really don't mean it, but it can plug a gap for someone who thinks I'm a bit short of this evidential aspect and I'm not going to clear the hurdle. That's well worth thinking about. And from your point of view, it might be different from your day job. And that's altogether a good thing in this application, because you're showing breadth all the time. And you can look at pro bono to link into those competencies. If it's an unfamiliar area outside your normal, there you are. New area of law, get up to speed fast. There's no magic about where you get it from, just get it for the purposes of the competencies. B, the advocacy, absolute classic, anything pro bono. If you're short of oral and you think you need someone, that might be your opportunity. But in any event, there will be advocacy, even if it's written, and it may be of a different type. And you may have clients there who are completely different from the job you do day in, day out. So I'm beginning to see what you've got in depth across the board. And D, diversity, action and understanding. You don't need me to say it for you. Quite often in pro bono work, those beleaguered souls who desperately need your help are precisely what is in contemplation in one aspect of diversity. They're hesitant, they're vulnerable, they're not big and gobby like me. They just get on with life in their inadequate way, and they need you, and you can give. What they need is fairness and that nice big J word, justice, and you can help them. And then you can put it in your form, and then I'll read it with a warm glow. Right, next slide, Chris, please. Thank you. I'm just going to witter on until someone says you're supposed to stop at slide 9 or whatever it is. So, okay, so I'm how did I know that one was coming? Right. Well, thank you for appearing to listen.
It's not like Anne and I do this regularly either. We've never done it before. So it's a regular double act. The interview section is interesting, and it's worth, I know that it feels like a long way off if you haven't made an application, but it's worth thinking about. It's worth us talking to you a little bit about interview, because we know from experience that this is what makes people quite anxious. The idea that they have to go to interview, what is it like? People at, senior stages of their careers have usually not been to an interview in a long time, can feel very stressful. You might feel like you need to use consultants, all the rest of it. And we just thought we'll just trail this for you. And of course, there's a lot more information on the website. But the interview, like the application, is competency-based. So Heidi will confirm that what we do is that we ask you questions based on the 4 or 5 competencies that that we're looking for evidence from. And in a competency-based interview, what we're looking for is examples. So a competence, the difference between a regular interview, tell me a little bit about yourself. You say, well, I'm more successful than X, who's already a silk. Well, that doesn't work. We want an example. So we want you to say, I'm experienced in going up against established silks, such as in the case of X, where I did this. So that is an example. And that's the fundamental difference between a regular job application interview and a competency-based interview. It's based on examples. So if you say in a competency-based interview, I'm able to use novel ways to use the law, that doesn't give us anything. But if you were to say, I demonstrated my ability to use, to find novel ways of applying the law in X case, where I was able to present an interpretation of Y legislation, that's great. That's a real example that tells us what you did. If you can tell us that it was accepted by the judge and found in your client's favor, that's an additional bonus, but it doesn't have to be. We are just interested in your usage and understanding of the law, but it has to be example-based. Every question must be answered with an example. That's what we are looking for in an interview. And often we find that, again, it is something to do with seniority, because we work in groups and employed barristers definitely work in groups. You often come across, we will say, we hear we quite a lot. We did this in the case. Well, what does that mean? What did you do? So learn to say I did rather than we did. What was your role? Because that's the question that will come back to you. But what was your role in it? So to think about it in terms of what value you added is quite helpful. The next slide is about the STAR approach. And we've got quite a lot of this again on the website when it comes to it. But the STAR approach is one of many approaches that competency-based frameworks use, not specific to the sector generally. And what it means is when you're preparing for an interview and an example, like I just said, you need to break down the example in this format. Think about what was the situation? So what was the task? And therefore, what action? How did you complete the task? And the very important last point that people forget to think about, which is what was the result and what was your learning? What was your reflection? So did you move the law along? Did you learn something that you hadn't learned before and you applied it subsequently? That kind of reflection really helps when you give us examples of the competency. So this is quite a useful mechanism. There are others. You don't have to use this. We don't prescribe them, but it's just an interesting way of thinking about the example, and it helps you to practice. So when you're practicing your example, think about it in this way. Can you break it down quickly? Because don't forget, although there's the rock star like Dame Anne in the room, but there'll also be somebody like me who doesn't know the law, and I need to understand it just as much as she will. Say. The interview, very important to share that the purpose of the interview is only to gather additional evidence. So we have, remember, a lot of evidence about you at this stage. We have your self-assessment, we have all your assessors, we've discussed it endlessly in moderation panels. We know your application very well, but there will be things that we don't understand, or we need to clarify, or we would need additional information. And that's the purpose of the interview. So typically you'll be interviewed by two people, one lay and one legal member. It's random. The secretariat put these jigsaws together. It's usually about an hour. It's usually in September and October. And we do there again, we've put it on the website. So when you get there, you don't need to remember it now, but there's lots of information. But how to prepare for your interview. You don't need many days of preparation. You need to think about the competencies, your cases, and give us examples from those cases when we ask them of you. And that's the preparation you need. You don't need to bring notes to the interview. We will help you. The panel is really happy to remind you of cases. It is not an interrogation. I keep saying this because, you know, especially for those applicants who come in, you're all barristers, lawyers. It's not, the purpose is not to interrogate you or to make you fall down or to find you faults. The purpose of the interview is to help you to give us your best evidence. That is simply the purpose of the interview. We are not there to find you out. That is not the purpose. The purpose is simply to add the information. So we are there, we are literally seeking information from you based on your application, what we know, to fill in some of the blanks, to fill in, to flesh out some of the information we've been given. And the purpose is to then take it all back to the panel. So we take the information we've gathered back to the panel. We don't make any decision at interview. It's not determinative. So some people do a terrible interview, I can tell you this, literally terrible, and they are fine because we don't get the information we need. But we can still look at the rest of the application and say, okay, this was a bad day for somebody, we can see that. So we don't hold it against you. If you had a brilliant interview, that's great. That's great. That will have added lots of information to perhaps, you know, a application where we were on the cusp and we didn't know. So the interview is not determinative in itself. It's simply an additional piece of information about you. I hope that's sort of helpful in deconstructing this idea. We thought that it would be useful to put up some misconceptions. Now, not all of you will have these, but over time we have gathered these, and we're very happy to hear more that you might have that we will add to this list for the others. So the 12 cases in the past 3 years is definitely not a strict rule. And it's not the case that you can't apply. We have lots and lots of examples of people who've taken career breaks, caring breaks, parental leave, have been in long inquiries over many years, and it's not possible to do 12. That's fine. And as Anne said, tell us why. That's the key, is just to tell us why. So we get a sense of your background and your context. It's also worth considering if you have a very important case that's beyond the 3-year mark, you can mention it, tell us, and tell us why it's important. Because even if we don't go to your assessors, we may talk to you about it at interview. The thing to bear in mind, however, is what we are looking for is breadth and depth. And if you don't have too many cases, it's really hard to get breadth and depth from your assessors because they simply haven't got the portfolio. So that's the downside. That's why we ask for 12, because we know with 12, we will get the breadth and depth, a good snapshot of what you have done. It's also there because we don't want anyone to game the system. We don't want you to pick and choose, you know, ones and then not some other ones. But more importantly, it is quite important to think about the time frame. So when we go back to your assessors, if your cases are beyond the 3-year deadline, which is possible, you can offer those, assessors don't remember. So we often get assessments that will say, I couldn't fully remember the detail of this case, or I don't quite remember his or her advocacy. Don't have enough. And so what happens is you've lost a voice, you've lost a crucial part of that information, and the panel can't do anything about that because we are reliant on that evidence. So it's a balance. So it's for you to judge how that works in your personal context. The desk-based practice and cannot fulfill oral advocacy criteria is more tricky. So the oral advocacy criteria is potentially difficult to satisfy if you're an employed barrister. Anne has talked about things you can do, like do pro bono work if you're that way inclined. We see quite a lot of solicitors, etc., moving to being self-employed because they can then offer that criteria. It is true that if you have no oral advocacy, it's very hard to fulfill the competency framework. That is just how it's set up. But having some oral advocacy will help. So we understand that there are specialisms where oral advocacy will not be the same quantum as other specialisms. That's just not the way it works. We get that. That's why we have the Dame Annes in the room who will tell us that. So we understand that, but having none is difficult. Then you don't fulfill the criteria. I need a coach to succeed in the competition. This one, we will beg you to please don't do. Please do not go to coaches, and please tell your friends not to go to coaching. Coaching is not required. Coaching is about confidence, we get that. But let me tell you that when we get interviews, when we get people at interview, we know the ones who are coached, because the coaches tell you to say things in a certain way. And all that the panel is trying to do, as I have said, is to gather your evidence, or as Anne says, get to know you, get to know the person you are. And if in that 45 to 60 minutes, we are just trying to get under the skin of what the coach has told you to say, you're losing time. And we are not getting the evidence we want. We encourage people, please don't use coaches. By all means, practice, by all means. Practice with your friends, practice with your teams, practice with in front of a mirror, practice your interviews, absolutely. But you don't need coaching. So if you don't do it, don't worry about it. You're probably on the right track. And finally, it is true that lots of applicants don't succeed. That's the nature of this process, isn't it? It's to highlight the best, the brightest and the best amongst you, which I'm sure you all are. But not every application will be successful. That is to do with mostly the evidence. Either the evidence isn't there, or your assessors, your peers haven't given us the right evidence. Anything is possible. We don't make any judgments on that. We don't make any judgments. The panel expects that most people will reapply multiple times, sometimes in the course of their career. That is absolutely fine. We understand that careers progress and you can apply. We don't ask you to justify at interview why you have applied. We do not. We are not interested. We don't want any speeches about why it's the right time in your careers. We don't. Frankly, we don't care, because we shouldn't, right? This is your time in your career. And if you feel that you are right to apply, you apply, and you can apply multiple times. I'm looking at the women because the women take longer to come back than men do. That's a statistic we have. So please don't, if we ever do ask you, and sometimes we ask you to make you comfortable, why do you feel it's the right time in your career? It's simply a conversation opener. There is no judgment. There is no judgment. And that's why we look at an application fresh every year. And we take great pains, and I as chair take great pains to let the panel know that if they spot an application and they might have come across it previously, we don't mention it, we don't talk about it, we don't refer to it, because it's a new one every time. So come back. That's all we've got. But very happy to answer any questions you have, and any suggestions you have for information on presentations like this that you or your colleagues might find helpful.
Yes, I was just going to ask if anyone in the room has any questions for Dame Anne and Monisha. And then perhaps, if I'm not sure who's policing, Stuart is policing online, in policing, but looking at online questions. Does anyone have any questions in the room? Gaynor, hello.
Hi.
I think you might actually, just so that it's picked up.
Click the switch. It's always a good idea, isn't it? So thank you so much, and I do apologize I was late. So it's not so much a question, well, I guess it is a question and a statement, really. So I chair the Bar Association for Commerce, Finance and Industry, and we have a number of individuals that work in-house. So we will have amongst that cohort some general counsel who, of course, have one client, potentially cannot do pro bono work because of conflict situations, will not have oral advocacy, certainly in the form of cases and evidence, because they'll have potentially, going in front of the regulators, the board will be their advocacy really. So I wondered whether there had ever been any thought historically to changing the criteria somewhat so that it's not just kind of the court-based advocacy, and so that general counsel, who quite often are very, very senior and are very used to advocacy, but in a very kind of contained way, whether that's in front of regulators who will not provide assessments in the main. Board members probably wouldn't either. CEOs probably not either. So I just wondered if any thought had been given to kind of that cohort of very senior barristers and their kind of career progression in the long term.
Thank you. Thank you for the question. It's actually a very good question. And I can tell you that most times we do this sort of presentation, it does come up. So there are two things to say. It's not on. That's helpful. Now it's on. Is it on? It's on. It's on. It's on. It's on. I was just saying thank you for the question. The truth is that the KC, so you missed the bit where we said, but that's okay, which is that we don't set the framework. So the KCA don't set the framework. It's set by the Bar Council and the Law Society together. And the framework they have devised, which is currently being applied, means that oral advocacy is a very important, so contested advocacy is a very important part of the achievement of the KC award. That's just how it is. So we only apply it. We don't have any further remit. Having said that, and it may not apply to you, I'm afraid, in your context, but we know that for oral advocacy, evidence could come from arbitration. It could come from court determination, settlement agreements, negotiations. So it does extend to the actual in a courtroom scenario, based on the kind of advocacy that people specialize in. But if you haven't got any of that, I'm afraid the framework simply doesn't stretch to your non-contested, no evidence scenario. Something to lobby the sector on, I'm afraid.
Yeah, I think just to come back, thank you for that. And that's what I expected to hear. I mean, I think the more I talk to students, so one of the things that we're also doing a lot of work on is bringing more pupillage capability into commercial organizations. So really trying to kind of underpin this one bar ethos. We've got a lot to offer as commercial organizations, but a lot of students will say, I don't see any silks that are general counsel. So what's my career path? And rightly or wrongly, that is held up as being a real kind of beacon for a career path for a barrister. So I do think that there are linked items there that we need to think about as a, as a cohort really, in terms of what is the future of the bar from an employed bar perspective and a one bar perspective.
I understand. Thank you.
Thank you, Monisha. Certainly sorry. Thank you. I think in terms of the advocacy competency, it's helpful to hear from you in terms of the written advocacy and oral advocacy. I often say to people that written advocacy is often the most important piece of advocacy that you do in a case. And obviously there are commercial and chancery practitioners at the self-employed bar that are able to satisfy those competencies. And what you said about pro bono work and also looking at arbitrations and negotiations as well, I think it is difficult if you don't have any of that experience to draw upon, but it's thinking laterally rather than I don't go to court for to actually think outside that box within reason, is what you're saying.
I am, and if I may, it's often been the case that, you know, we talk a lot to solicitors, for example. They are part of this process. They don't apply in the same numbers as barristers do, and quite a lot of them tell us that it doesn't apply to them. It's a great award to have, but it doesn't make a difference in terms of their career paths, the way they progress, the way they, you know, and that's fair enough, I think. So as I said, our involvement is very, very limited. And there is clearly a discussion to be had within your industry.
I'll just ask a follow-up question on that then. In terms of the advocacy. Yeah, so. In terms of the advocacy point then, is there any weighting towards written and oral advocacy? If principally your practice is written advocacy, but you can score, I don't know, 20% of it you can make up from the pro bono side with something that's interesting and challenging. Is that sufficient or is there more of a bias towards the oral rather than written?
No, we don't deal in hardline sums and mathematics. We have a look at the overall picture and we don't do 50-50 oral and written. We look at written and oral. And we are, I know it's a broken record, I do apologize. We are after a complete picture of you and we'll work it out. I think that if I could persuade people to think as broadly as possible, when you were speaking, this was occurring to me, of what the word advocacy imports. There's the professional setting, the strictly professional and hence pro bono. But there are things like boards of governors. I sometimes think to myself, if one were available as a governor to help with a grievance procedure or to represent someone or to turn up as their friend or something in parallel, it is, after all, an exercise in advocacy. And if nothing else, it's a start. So my long answer to your good question is we're flexible and no, we don't do sums.
So would that mean, say, for example, you had lots of glamorous examples that hit all your core competencies in your writing, but say the oral ones, although you've got a few examples, are perhaps less, they're not your strongest suite. Is that adequate?
Yes, yeah.
As long as collectively
Yes,
you
that's,
can.
that's right, because we won't do simple sums.
Yeah,
it's you,
perfect.
and we will understand you and do our best with it.
Understood, thanks.
Yes. So there will be an article that Anne has drafted that will come out in the Counsel magazine in a couple of months' time, in April. And that will give you exactly this information. It's sort of main FAQs, and that's what it will also say. So we know what the specialisms, how the specialisms work. That's the joy of having legal and lay members. Lay members may not, but legal members do. And so they can say, well, in this kind of specialism, planning, one example, where it's not possible. You won't have the same kind of oral evidence, advocacy evidence, as criminals might. And so we allow for that. We judge it on that basis. But interestingly, it's the assessors who tell us that this is not a usual example. This is a sterling example of oral advocacy from somebody who doesn't do it all the time. We get that from your assessors. So long as you have the cases that you can put forward, and we allow your self-assessment will allow that little paragraph where you can say, I don't normally do oral advocacy. However, these are the 3 cases where I have. That works, yeah.
Anyone else in the room? Because I can see that there are 5. Helen, yes. We can bring that one back. Thank you.
Thank you. I just wanted to ask, for the applicants from the employed bar, what does the typical assessor look like? What would you expect?
No. Shall I?
There isn't a typical. They vary because the employed bar is quite big. So if I took James from the CPS and his likely assessors. They would be completely different from Georgina's and completely different from Baxi. So there isn't a typical. All we are ever interested in is the quality of what the assessor knows about you. And that's why occasionally, perhaps less relevant for you than for the self-employed bar, we will generally say, don't go for status alone in the assessor. If that particular LJ has seen you once doing an application, go for the experienced circuit judge who's seen you day in, day out, day in, and can show us you're consistent. And that translates into every category of applicant. What we want is an assessor who can give the best about you to us.
Yes, it is.
Thank you. We've got some questions from online. Someone has asked about assessors. How did the panel recommend we meet the criteria for 12 judicial assessors in the case of those who have a desk-based practice? And as a follow-up, are applications without 12 judicial assessors acceptable? I think we've covered the 12. But there's possibly a question that comes off the back of that I think some people may be not concerned about, but wondering about. If you have a principally desk-based practice, you're dealing with arbitrations and negotiations. I think you've just touched upon it, Dame Anne, where you're not looking for status in terms of assessors. But some people will be worried about, I haven't got an LJ or I haven't got a High Court judge. You could do that because you were one. So, but is there a bar to put in an application in without that sort of assessor? And more importantly, how do those assessors get assistance as to the competencies? I know that the website is very useful, but it's just really, I think assessors is so important that some guidance on that.
They are. And if I could get going, Monisha will fill any gaps I leave. It is a repeat of what I've said. You want an assessor who understands you and in depth and as often as possible to give us a good picture. It doesn't matter nearly so much what their rank is. What matters is the quality of their information. Of course, in an ideal world, you would flick your fingers and you'd be deluged with willing High Court judges and the odd lunatic LJ who would be very keen to speak well of you and over a lifetime. Marvelous, but very few have that counsel of perfection. So it's extreme. Oh, I don't know why I'm talking to you lot, because I should be talking to the computer. So it's very important, whoever posed that. Right.
Yeah.
It's very important that we get across. Status is only status in a limited respect in terms of its efficiency. What you want is knowledge and depth, and you want the assessor to give a good, complete, honest picture of you.
So just to add to the guidance for assessors, when you have assessors, and so you can't draft their stuff for them, you can't tell them what to say, et cetera, which you will all understand. But what we want from assessors, and it's useful for you to tell them, is the detail. We really want to know how long they've worked with you, how well they know you. As Anne has said, we want to understand what is the context of the case. It's no good. Assessors sometimes think that the best thing they can do for an applicant is to say, oh, she's just brilliant. I love her. I've worked with her. I wouldn't choose anybody else. That's great, but it doesn't give the panel any evidence. And one day you will all be assessors. So I'm telling you in the hope that the assessments are better. We just want some honest feedback. We want to know things that went well, things that could be improved, things how well they know you, how much they've worked with you. And that, there is no perfect assessment, because we will look at perfection with some cynicism. There are some awful assessments, let's not go there. But most of them are the good ones, the ones that are valuable are the honest ones. And for you to think about, if you're an applicant, the status only matters because it sometimes applies to competency A. Competency A is about understanding and using the law. And sometimes if you can prove that you have a case that you have argued in the upper courts, which is more about the law less about the facts, but more about the law. That helps with competency A. So that does help. But we don't need, as Anne has said, a slate of judges who are very, very well known, who we all recognize and, you know, doff our hats, but will only say something like, oh, I saw him in my courtroom for 2 hours. He was fine. And we do get assessments like that. And if that has no value to us, as you know, in terms of judging, in terms of evidence. So while it's nice to see, it doesn't help the applicant.
Thank you. I'm just checking to see if there's anyone else online because I have the computer in front of me.
Meanwhile, we have a question in the
Do you
room.
have a question? Yes, Mr. Posner, who I
Oh,
do
yes.
know.
Thank
Yeah, hi. It's just to clarify something that you said about the interview and how the interview adds more depth to the application. For those successful in getting through to an interview, are you asked questions beyond the 12 cases you have and the qualities you need to demonstrate? Do I need to have other examples available? Thank you.
Yes and yes.
Okay.
Your 12 cases you can put on stage. They've been in self-assessment. Repeat them, but take the opportunity to think of whether you can add some more. All we want when we're dealing with cases is cases, and where they have sat is neither here nor there. So you shouldn't feel, Stuart, constrained in any way to stick to the 12 cases. It's your career we're interested in. So if necessary and if apt, and you come along, just imagine you've come along for an interview, and since you've finished your application form, there's been an absolute cracker of a case which deals with 2 competencies in it. Tell us all about it. Is that all?
It does, thank you. And the only other second question, forgive me for asking it, is do you...
Yes, no, sorry, we've had some messages saying you are flashing. We've had some messages saying that people can't hear online, and I think that's because the battery is about to die now. To get whether it's worth. Yeah. It's there we are.
It's quite a tricky one to ask, actually. Do you find assessors generally, because having assessed before, to do it properly requires a lot of time and thought when you've not got time for your own career, let alone someone else's.
Yeah.
So do you find generally assessors are committing themselves to doing it properly?
Assessors go to an enormous amount of trouble. I can't take my hat off to them firmly enough. And you will see in the article that's going into council that they are the unsung heroes, and they do it all in their own time, and it is a tremendous burden. It is right to say, as Monisha has adverted to, a technical term known only to judges. Some people would say mentioned. It is right that occasionally an assessor will not quite hit the spot, because when you've got through all the words, you've not got as much there in substance as you really would have liked. That's a different point. I've only the greatest of respect for what the assessors try to do and the efforts they make at personal cost to themselves.
Thank you. We've got another question in the room, and then I've got one online, and I think we're possibly reaching.
If an applicant has a judicial position, so sits part-time, are we entitled, are there persuasive examples put forward from that capacity in your experience?
Yeah. If you've been sitting as a recorder and we've had bowled at you a case which was completely foreign to you, didn't know the law at all, and you've got to bone it up overnight, there you are, you've boned it up overnight, you've reacted at pace. What we're not interested in is in your judicial skills for this purpose. But the content, if it is apt for the competencies, is the content.
And that example actually is a good one for competency C and D, the working with others and the diversity often comes. So we do say, in terms of your question earlier about other cases, we do say that where you have examples, we will take, on diversity particularly, we will take examples from your personal life, outside of your professional life, so that you can tell us how you understand it and how proactive you are. Ideally, we want examples of how you have helped to widen access and participation within the law. However, if you are also, participating, we've had such wonderful examples of people spending time participating in youth centers, doing pro bono work, working with the homeless. And all of that is about increasing the understanding and awareness of diversity and the different perspectives from the community. Because ultimately, the guidance to us as the panel is that we want KCs to be role models. We want them to understand people from all walks of life and be approachable and fit for purpose. So that is acceptable in the context of the semi-judicial roles. And in terms of if it helps for competency A, the examples are, if you may have cases where you have not listed in your 12 because they're just outside, as Anne said, either very recent or slightly outside of the time frame. But if you've researched a new or developing area of the law, if you've applied it creatively, if you've used another area of the law that is not your specialism, whether or not you appeared or not, you could bring that to the interview. And we're very happy and interested in hearing examples. So it's up to you to decide whether it's relevant or not to the question.
There's a question online, which I think possibly goes back to the oral advocacy point, but it is quite an important point that comes up again and again for those of us at the Employed Bar who are thinking about this sort of application. And it's this: what is the panel's advice where you work in a complex but high volume output area such as public, parliamentary, FOI data protection? So in other words, your work's very high volume, it's contentious, you're routinely persuading internal committees with senior colleagues and so on with verbal submissions, but you're never in front of the court. Does that count as oral advocacy for the purposes of the criteria? And I think that's possibly a question that many people will have. It's those internal submissions. Who was Monisha's going to answer that? Because
I get the easy ones. The answer is they don't work, I'm afraid. They won't work. If you imagine what the framework asks of us to do, it is about contested advocacy in the main. It is about contested advocacy in the main. So when you have negotiations, we will want to know that it was external, that they were independent, it was contested in a real sense. And it doesn't work for many types. Exactly in this situation, it won't work. And that is exactly where we find that those who are very keen on participating in the competition do find and admittedly have to find the time to do pro bono work or other work from other areas of the law. And it sort of slightly segues quite nicely into the fact that we're very lucky to have Rebecca Wilkie, who is here. She's the Chief Executive of Advocate and is happy to speak to anybody who would like to discuss in more detail how pro bono work can support silk applications. We have seen applications where people have deliberately gone out of their way to get evidence and be able to offer the evidence. Yeah.
Thank you. Well, I can see what the time is, and I think we've got a little over time. Thank you to both Monisha and Dame Anne, and to Hannah and Jackie as well for helping us put this together. It is an important event. We hope we'll do more with you. And we thank you for your time, and we look forward to your article, Dame Anne, which will answer, I suspect, many more questions. But thank you very much to both our speakers. Thank you.
Thank you.